All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Jennifer Kansas presiding, is now set. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have 3 cases scheduled to be argued this morning. When I call your case, please stand, state your name, the party you represent, and your readiness to proceed. The first case on the docket this morning is a combined case under the top case number of C-24-0172 in Re AC.
Good morning, Your Honors. Margaret Kane on behalf of the appellant, AC. Ready to proceed.
Norma West on behalf of the state of Ohio, ready.
The second case on the docket this morning is under a combined case number. The top case number is C-25-0018 and Re C and S children.
Good morning, Your Honor. Kathy Blackberry on behalf of the appellant, AC JFS.
Are there other attorneys present on this matter?
Good morning, Your Honors. Alex Sanders, the attorney for Mother Jennifer Blackgrove appellant.
Good morning, Your Honor. Cynthia Dory, attorney for father Matthew Fox Sr.
Good morning, Your Honors. I'm Jeff McCormick. I am the attorney for the guardian ad litem and the court-appointed special advocate in this case.
All right, thank you. And the third case on the docket this morning is C-24-0412, Niehaus versus TDGGC LLC.
Good morning, Your Honors. Charles Rush for the appellant, John Newhouse. We're ready to proceed.
Good morning, Your Honors. Matt Pacoda for TDGGC LLC, and we are ready to proceed.
All right, thank you very much. Just as a brief reminder to the attorneys, we have 2 cases on the docket this morning that involve minor children. Please do not identify the names of the minor children in this morning's arguments. Ms. Kane, if you're ready, you may come forward. Would you like to reserve time for rebuttal?
Yes, 3 minutes, please. May it please the court. This appeal involves numerous case numbers, but for purposes of this argument, I'd like to focus our attention on AC's adjudication for felonious assault and the attendant firearm specifications. AC's felonious
So
assault.
would you agree that the identity assignment of error, that was not raised in the objections?
That's correct, Your Honor.
All right.
Regarding the felonious assault adjudication, the evidence failed to establish that AC attempted to cause harm or that he intended to use the vehicle as a weapon. I want to start there. In incidences involving an object that was not specially designed or adapted to be used as a weapon, in order to find that it was a deadly weapon within the meaning of the statute, courts have to apply a 2-step inquiry to make that determination. First, they have to determine that the object is capable of inflicting death. We do not contest that a vehicle is capable of inflicting death. We know that that is true. The second part, however, is really crucial, and that part requires a finding that the defendant intended to use the vehicle as a weapon. In this case, the evidence does not support an inference that AC, if we assume he was the driver, intended to use the vehicle he was driving as a weapon. In this case, AC was not driving very fast at all.
Well, counsel, didn't the witness testify to a version of events that, if construed in the light most favorable to the state, would support the idea that AC intentionally collided using this vehicle with her car? And I'm referring specifically to her testimony about the second collision, where there was like a tap or a hit from behind, and she said that she couldn't tell if he was trying to go around her or was purposefully bumping into her.
Right. So there are a couple of points there. So Regarding her affirmative response to the state's question about whether or not she believed it was intentional, I want to note that because this is dealing with the mind of the defendant, her opinion about whether or not there was intent is purely speculative. So we have to look at her allegations or her statements about the circumstances around it to determine whether or not it's appropriate to infer intent. Here, it would not be appropriate to infer that he was trying to use his vehicle to hit hers. In this instance,
What the trial court relied on is that it was likely to create a certain result. So that's one part of my question. The other part of my question is, there's 2 hits where the testimony supports that he purposefully backed into the vehicle. So how do you get around the knowingly in that second part?
So regarding the first, and I'm not sure if this is what you were getting at, but the first collision, the allegations were that he was hanging out the window, he turned left, and immediately after he turned left, he collided with her vehicle. In that instance, I think that it is the only reasonable inference is that that was a normal accident. The fact that he was hanging out the window, while that may support an inference that he was driving, or a finding that he was driving recklessly or negligently, careless or reckless driving of a vehicle is not enough to infer that the driver intended to use the vehicle as a weapon. And that was something that the court in Nassau specifically found. Regarding the second hit, I think that there are a couple of facts surrounding this that are important to keep in mind. First, he was very young. He was 15 at the time of this incident, which is something that the witness testified that he appeared to be very young. He didn't appear to be someone who would be of an age where he was a licensed driver, and so he was probably very inexperienced. The second part that is really important to keep in mind is she testified that he backed up just a little bit. So that suggests that he didn't back up a lot and then accelerate at a high speed forward and hit her vehicle. Instead, what she, as Judge Kinsley indicated that she wasn't sure what he was trying to do. At first, it seemed like maybe he was trying to get around her vehicle. It was a very light tap by the prosecuting witness's own testimony. And so based on that, that does not suggest that he was intending to use the vehicle as a weapon.
What about his conduct immediately thereafter? When he, according to her, he tells her, you know, you need to like pull around the block, and then he brandishes a firearm. Can we look to that to ascertain what his intent was in that second incident?
No, I don't think we can, and there are a couple of reasons. First, and I'll be happy to get into this a little bit more, but I think that there are some really valid questions about whether or not what he was holding was actually a firearm, although I do understand that that is what the prosecuting witness testified to. But there is no statement from the prosecuting witness that suggests that he was threatening her, either explicitly or implicitly. In fact, she testified specifically that he never pointed it at her, he appeared to be joking, and he sped off right thereafter. So this isn't a situation where someone brandished a firearm and then said, hey, give me your keys, or give me your money, empty the lockbox. And so in this instance, while she did allege that he held what she thought might be a firearm by his face, he didn't do it in a way that was suggestive that he intended to use it to harm her, or even that he made any representations either through his body language or through his words that this was in fact a firearm.
And the issue with the firearm is distinct from using the car as a deadly weapon, right?
Absolutely, especially when we're thinking about the facilitation specification. And there's very on-point case law out of the 8th District and the 2nd District that deals specifically with when facilitation specs can attach.
Well, I'm going to focus on the car as a deadly weapon, though. In those cases that I think were cited in the briefing, usually it's a kind of domestic situation where the driver is intentionally targeting the victim with the car. Is that-
Exactly.
Is there any evidence that anything like that occurred here?
No. The prosecuting witness testified that she had no prior relationship or encounters with AC, so they didn't have any sort of tension between them that could have given a basis from which to infer that there was hostility, which is distinguishable from a lot of the cases that deal with when cars are used as deadly weapons, is domestic violence situations occasionally, disputes between partners, or at the very least, an indication that there is road rage or anger that exists between, or at least on the part of the defendant. In this case, there's nothing that would suggest that this was a road rage incident and that he was slamming into her. Some other factors that courts have considered when determining whether or not a vehicle was used as a deadly weapon, they've looked toward things like, was the individual chasing the other individual? So in numerous cases, there's evidence put on that the vehicle had followed, the defendant had followed the victim in their vehicle for multiple blocks for a duration of time, repeatedly hit them and tried to push their vehicle off the road. There's been evidence of high speed. So in one case, getting up to 70 miles per hour, chasing after the vehicle and hitting them while the victim's vehicle is trying to get away. There is nothing anywhere near that in this case. This case is much more akin to a situation that would be associated with a minor vehicular accident, not a criminal offense, and certainly not a felonious assault. There's no case.
Let me
Yes.
try to understand. Are you arguing sufficiency, manifest weight, or both?
I'm arguing both.
Okay. So on sufficiency, what is it that there is absolutely no evidence with regard to? What element are we missing?
Intent to use the vehicle as a deadly weapon.
And you do agree that it could be direct or circumstantial evidence that goes towards that?
Certainly.
So are you saying there's no circumstantial evidence with regard to intent?
Intent to use it as a weapon? Yes, I am saying that the evidence would not, that the evidence that was presented does not support an inference that, a reasonable inference, that he intended to use the vehicle as a weapon.
Well, intent is also, could be discerned with actual intent, but also when an action is likely to cause a certain outcome.
Sure.
So I think that's the part I'm more interested in, on the evidence on his behavior on both, when he's hanging outside, which that one the trial court speaks of specifically in the entry, but also on backing into the vehicle, and how is it that he's not likely to cause a specific outcome?
So regarding the first collision, I think that the trial court makes the mistake of conflating the mens rea. And so the trial court indicates that, hanging out the window is something that a reasonable driver, a reasonable person would know or understand may have the effect of an accident. Now, that is more akin to a mens rea of recklessness or negligence than it is to knowing. Knowing requires that the individual engaged in conduct that they knew was likely to result in a certain outcome. And in this case, I don't think that we can say that it was likely or almost certain that he was necessarily going to get in an accident. While it was reckless or negligent behavior to drive in that way, again, as Nastal held, there's the mens rea of intending to cause harm, and then there's the mens rea of intending to use a vehicle as a weapon. And those are distinct issues that I think we need to kind of make sure that we separate out, because one, I don't think we established, that the evidence established that he intended to cause harm, but two, it certainly doesn't establish that he intended to use the vehicle he was driving as a weapon. And So as the court has held, careless or negligent use of a motor vehicle does not equal use of a vehicle as a deadly weapon. So in Nassau, it was a truck driver who was in a construction zone and cars were slowing down around him. There were many signs indicating that it was a construction zone. He was a semi-truck driver, so he had a CDW, and he failed to remove his cruise control and ended up killing 2 people and seriously injuring 2 others because he failed to apply his brakes until 2 seconds before collision. And in that case, which I would say is even more dangerous conduct in some ways than what you see here, where, again, AC was driving at a low speed. But in that case, the court found that there was no evidence that he intended to use this truck as a weapon. And so his charge from vehicular assault couldn't be reduced to negligent assault, which requires deadly weapon. Here, I think the same sort of idea applies, that there isn't the requisite, in terms of circumstantial evidence, the circumstances surrounding this collision absolutely don't support a determination that AC was intending to cause harm. If he had intended to cause harm, he would have accelerated faster into the vehicle. He wouldn't have sped off right thereafter. Had he been intending to cause harm, there would have been something else to suggest that.
It seems that the pivotal piece is that he's driving the vehicle. And in driving a vehicle and driving it in a specific way, it seems to me that that's where the court is getting the intent from, as opposed to your example where the individual was not operating the vehicle or driving the vehicle.
So
Maybe I misunderstood the other case.
The other case, I mean, he was still operating the vehicle. He failed to apply his brakes, and, you know, when you're operating a vehicle, especially at a high speed on the highway,
Okay.
you know. If it's okay, I'd like to shift to the facilitation specification.
Counsel, you have about 1 minute remaining.
Okay, so very briefly then, regarding the facilitation spec, as I said, there are cases that are on point that deal with parallel factual circumstances that indicate that where a firearm is brandished or displayed after the conduct that comprises the offense for which the facilitation spec was attached, that any display or brandishing thereafter, even if it's related to a different offense, cannot attach to the original offense. So here we would ask that this court overturn the facilitation specification. It was inappropriate. It had nothing to do with the conduct that was alleged to be the felonious assault. And I'll reserve the remainder of my
So I want to
time.
make sure I understand what you're saying, because both specs have the language of while committing the offense. So had a firearm on or about his person or under his control while committing the offense, okay? The 3-year then goes on to say further elements. So the while committing the offense, you're saying doesn't have like a plain English meaning to it?
No, I'm not saying that. And the argument regarding the facilitation specification is, so that's the 3-year, is distinct from the argument about possession. And so this court could potentially find that he did not brandish, display, use, indicate possession of the firearm during the commission of the predicate offense, which is the felonious assault.
The trial court here, just so I'm clear, the trial court imposed the 3-year specification, right?
Correct.
And that, by definition, eliminated the 1-year specification.
It would have merged, yes.
All right.
For purposes of sentencing.
All right, do you have a position, and I realize this may be a difficult question for you, but do you have a position as to whether the 1-year specification would have been proper, assuming that the felonious assault was proper?
For different reasons, I would argue that neither was proper, but the argument relating to the possession specification is distinct from the argument that I just made about the facilitation and has to do with operability.
And that's an argument that you have not raised because it merged.
I raised it because it would also remove the facilitation specification, and so it's raised in the brief. It's not something that we've talked about today.
All right.
So I do have a question. I'm going back to the objections. Basically, the objection on the firearm specifically states, and this is all it states, the magistrate erred by finding that the state proved beyond a reasonable doubt that AC possessed the firearm during the commission of the charged offenses. The victim testified that she could not say for sure that the gun was an actual firearm. Okay?
Right.
So there's nothing beyond that except whether the firearm was a firearm in fact or not. Okay? Do you see something else in the objection that I'm missing?
So I just want to make sure I'm answering your question. So are you asking about whether or not the argument that I raised regarding the facilitation specification and its applicability in this circumstance is an argument that was proper to raise on appeal because it wasn't addressed specifically in the objection?
Well, first, I want to see whether it was raised on the objection.
So the sufficiency argument on the firearm facilitation specification that I raised was not specifically raised in the objection, but is something that this court can consider because sufficiency will, in almost any circumstance, fall within the purview of plain error. So even if the trial attorney failed to raise that specific argument, it's still something that I think that this court can consider. Regarding the other part of the question, yes, you're right, that the trial attorney on objection was focused on whether or not the firearm alleged was a real firearm.
Okay, so on this firearm, you're raising both manifest weight and sufficiency, is that correct?
That's correct.
Okay, so beyond whether the gun is an actual gun, are we able to address manifest weight? Because it seems that there's case law that says that we can't.
So
But
I apologize.
And I'm going to take a step backwards because anything beyond actual firearm, what is our standard of review? What is our...
The standard of review would be plain error, but essentially dealing with sufficiency, which, and I apologize, I'm trying to remember if that was something that I dealt with in the reply brief or if that might have been a different case. But I would be happy to provide additional briefing regarding the standard of review as to that particular argument. And to just very briefly clarify, the argument that it cannot attach, the facilitation specification, the 3-year specification, cannot attach to the felonious assault is solely a sufficiency argument. There's no manifest weight as to that portion of the argument. And I believe, but I would be happy to provide additional briefing about
Well, I'd
standard.
rather address it now, I think, because you, in your standard of review, don't articulate that it's plain error. But you acknowledge that it wasn't raised in the objection. So it sounds like you are saying that it is plain error review.
I think that there are two ways. So
I think this is important because the state needs to respond and needs to be clear on what the standard of review is.
Sure. So in the objection, trial counsel challenged the application of the specifications to this charge. They focused on whether or not it was a real firearm. I think that leaves open the opportunity to also argue about whether it was appropriate based on sufficiency of the evidence and manifest weight as to that particular issue. I think it also allows us to argue that there was insufficient evidence to support the facilitation specification on these additional grounds.
Okay.
But if you don't want,
So you agree that manifest weight would not apply on the additional grounds because we're under plain error review?
correct.
Okay.
Yes.
It sounds like you agree that it is plain error review on to anything that you're able to raise on appeal.
I think that I'll leave it to this court whether or not it has to be reviewed under plain error or if it can be reviewed under sufficiency. I think that the trial attorney's objection relating to the specifications preserved the argument, but if this court is not persuaded that there is enough within the articulation of that objection to support this other argument, then I would ask that it be reviewed under plain error and that has been preserved because sufficiency is preserved by a assertion of not guilty. So I would ask that this court consider the argument.
I appreciate that, and I appreciate that, obviously you're doing the best you can on what has occurred before your representation on appeal.
Thank you very much.
We'll give you some additional time.
Okay, thank you. May it please the court and opposing counsel, maybe just because it's all fresh in our mind, I'll start with the state's understanding of the firearm specification arguments. It's my understanding that
Because you do acknowledge that in your brief, you also don't address the standard of review and whether it's plain error.
What I'll say is I think both of those arguments are contained in the original brief under the first assignment of error, which makes reference to the sufficiency and manifest weight standards. With specific reference to the operability of the firearm, I do think that was properly raised below, and that would be either, I forget if it's, whether it's sufficiency or weight, I think either would be properly preserved.
I think that both are being raised, yes.
And maybe you can, and I look back at my brief just to make sure, my understanding of the argument, at least as it related to the facilitation specification, was less about the sufficiency. To me, it read more as a plain error standard, making an argument based on the interpretation of the statute and whether or not that was correctly applied. I realize that plain error isn't referenced in there, but to the extent that they were making an argument as to how that statute is supposed to be interpreted and applied, I would think at the very least this court's review of the interpretation, the legislative intent of that statute would be de novo. Applying that interpretation, I think, would be under a plain error standard. About it, to that extent, the question, assuming that even if the court got it wrong.
So it's interesting what you're saying, because you're kind of saying an issue of law would be de novo, but when I look at Juvenile Rule 40, it seems to speak otherwise, because it says, except for a claim of plain error, a party shall not assign as error on appeal the court's adoption of any finding of fact or legal conclusions. So it seems to include de novo legal conclusions. What would normally be de novo?
What would normally be de novo? I guess what I'm saying is that I believe that they're limited to plain error in that sense, as this court reviews the interpretation, even if this court were to determine that there was some sort of error that affected, it would have to find that a different result would have came about as a result of that interpretation.
Well, prejudice.
So, yeah, prejudice. So
in
prejudice
plain error, we're
would be,
going to have to deal with prejudice. I understand that.
Assume for the moment that a person is convicted based on, or in this context, a juvenile is adjudicated based on insufficient evidence.
Mm-hmm.
Would that be a plain error?
I think that would be one element of plain error, depending on what the. I don't know that I'm prepared to answer that today, Your Honor. Unfortunately, my gut feeling is no. I would have to look again at the elements of plain error, in the context in which that. But
would it be prejudicial to the person if they were
I would think
adjudicated of something based on a lack of
Insufficient evidence? I would think so, yeah. But there might be more legal, I think at that point we'd have to define what we're talking about in terms of the terms of plain error and legal sufficiency, and in what context we're talking about, whether that's the elements of the charges, whether that's the charge itself, whether that's, for something like this, a specification, which is not an element of the charge, but merely a sentencing enhancement. So unfortunately, I can't give you a straight answer today, as much as I want to.
Yes, thank you.
I think, but just to speak directly about the facilitation specification, I think, Judge Zayas, you've pointed this out quite well. I think even under just the plain reading of that statute, we've met what we need to here. The plain language of the statute is that the offender had a firearm on or about the offender's person or under the offender's control while committing the offense. As I see it, that's the first element of that specification.
Right, and it seems that as if the argument goes to the while, but it sounded to me like it was a definition that was outside of plain meaning.
So my understanding of the argument is that language, while committing the offense, is something that has to, as I understand the defense's argument, has to be applied both to the possession of the control, or possession or control of the firearm, and when that firearm was displayed. But just reading the plain language, I mean, and I argue this in my brief, the offender did have a firearm on or about their person while committing the offense, and they displayed the firearm. To me, that is meeting both of those elements required for that specification.
Does the state have to prove that the firearm was operable?
Yes, they do, Your Honor.
And what evidence is there that the firearm worked?
So the law is pretty clear that operability can be proved through circumstantial evidence. So it's while we have to prove that it's operable, we do not have to demonstrate, for example, that it was like test fired at a range or something like that. We can prove through circumstantial evidence. Where that comes from in this case is the implicit threat to use the firearm. In other words, if you're going to threaten someone, a fact finder can take the can make the assumption that you would only threaten someone with an operable firearm.
My understanding is that he raised the firearm, put it next to his face. He didn't point it at the victim in this case. Is that correct?
I think that's what the victim testified to. We argue that would have been an implicit threat, which gets more into the intent for the felonious assault, which I plan to speak on next. But yes, I think that is how the victim took it, as a threat. Essentially, after crashing into her twice, he pulled up alongside her, showed her a firearm, and said, "Hey, pull over onto that side street right there." And then before she could have time to react, he drove away.
Now, you said crashing into her twice. He crashed into her, then he backed up, and there was a light tap, is I think how it was described.
Sure, and I mean, the evidence is there for you to, if you disagree with crashing. I think her testimony is that the second time that she was struck, hit, was not very substantial in terms of.
You're not suggesting that he continued to ram the car into her?
I wouldn't use the verb ram. No, I don't think so. I didn't mean to. So no. I think, and specifically when I don't know if I've answered your question as to the operability specification.
So nothing beyond the fact that he raised the gun and put it next to his face?
She also, I think also her testimony that the firearm, I think she said she's familiar with firearms. She looked at it, she knew it was not a toy. And so in line with what this court has held in the past, I do think that we've met the burden for proving through circumstantial evidence that the firearm was operable, even though no firearm was recovered.
She also said she could not be certain that it was real.
Correct. Again, that's for the trier of fact to make a determination as to her credibility in line with all the other circumstances. And I think the same thing would go. We heard her talk about, when she was asked what she believed was happening, she said she couldn't be certain whether he was backing up, trying to get around, and struck into her. The cars came into a collision with one another a second time. And she said she couldn't be certain. She did answer in the affirmative that she believed that both strikes were to be intentional. And obviously, as opposing counsel has argued, the mind state of the mens rea of the defendant is something that we don't have a direct link to. We have to have it proved through circumstantial evidence. And so,
Counsel, what about this line of case law that your opponent has cited, that displaying the firearm in what I'll call escape after a crime is committed is not sufficient to establish the 3-year specification? Can you help me understand when this crime ended in terms of the felonious assault and when the weapon was displayed such that it would have not been in the course of escape?
So at least for the Peacock case, what happened in that case? In that case, the state conceded that it was a separate time frame, there was no concession made in that part. They struck someone who was riding their bike, if my memory serves. They struck someone who was riding their bike with their vehicle, and then after they struck him, that was the felonious assault. They got out and they robbed him with a firearm, and so they disconnected those two incidents. Our argument here is that at least for when courts are examining the nexus of events that happens for firearm specifications, that time frame maps onto the, let me get the right language here. I believe it's the nexus of events that took place, the act or transaction, a series of continuous acts bound together by time, space, and purpose directed towards a single objective. And it's our argument that, at least as to that element, when a court is trying to determine whether or not that was part of the same set of series of actions, all relevant to the same criminal proceedings, that is what you would look at. And I think specifically, and I want to be clear because I feel I have to sort of untie what we're looking at here for this felonious assault, which is what was argued first by opposing counsel. We're not talking about, as I understand opposing counsel's argument, she would require this court to find a specific intent to use the car as a weapon, which is not the standard here. The mens rea element is knowingly, and Judge Zayas, as you've pointed out, when we're talking about knowingly, we're talking about the ability to foresee actions. And in this case, I mean, the case...
Well, that's the mens rea for the statute, for the elements of felonious assault.
Correct.
But then it does seem that case law, confusingly perhaps, has added intent to the definition of deadly weapon when the weapon itself is not inherently deadly.
Mm-hmm.
Can you help me understand what that means and what we do with that, given that the definition might include some elevated mens rea?
And this is where I want to make sure we're untangling what is actually at issue here, because it is true that we have to find that someone knowingly intended to cause physical harm or attempt to cause physical harm. That mens rea is active. It is also true that the court has to find that the other part of that statute is with a deadly weapon, by means of a deadly weapon. So the court has to prove, or the state has to prove that there is a deadly weapon in focus here. And when courts are examining whether or not a weapon is a deadly weapon, they focus on the capability to inflict death or body harm, and that is determined both by an object's nature and its manner of use. So when we're trying to talk about, when we're looking at whether or not a hammer is a deadly weapon, we're going to look at its ability to inflict harm with something, but also how it's being used. In that sense, I do think there is some examination of the intent that follows into whether or not a hammer is a deadly weapon, meaning, what it was used to do. But I don't think that I wouldn't describe it as an element of felonious assault in that sense.
So in this case, the driving of the vehicle, how does that fit into what you're saying?
Well, and I'll work from behind when we talk about, I think realistically what I think the argument for sufficiency and weight boils down to is this first strike was an accident. He got into an accident, he tried to get away from the accident, and, that's where I think. And I think that becomes more strained when we look from, from the end of the incident to what happened. He drove away from the incident at high speed. I think that to me shows that there was intent to, escape or flight is evidence of consciousness of guilt and therefore evidence of guilt. Before that, when he confronted the victim, he pulled out, and they're not challenging the menacing conviction, the adjudication, pulled out a firearm, said, pull over to that side street over there. That to me does not read like someone who is, who's simply been in an accident. There's that second hit, so, I think the fact that he was able to pull out and pull alongside the victim's car demonstrates that he had control of his vehicle, but he hit the car a second time. That to me does not read that the first strike was an accident. And then of course you have the first strike itself, in which case, by my understanding of the facts, he was proceeding he was going, I think the victim said approximately the speed limit when he turned into it. I understand that he was hanging outside of the vehicle, but as you can see from State's Exhibit 5, I believe he was in full control of the vehicle. And so then we go to what courts have used for determining someone's intent for the long time, that mere commission of an act itself is evidence of someone's intent to do that thing. I guess it is entirely
You're
possible.
going to the mens rea of the causing physical harm, or are you going beyond that?
No, I think I'm going to the intent to cause physical harm in the first strike. I think the words of the judge were that the judge believed that both strikes would constitute felonious assault.
And it sounds like you're asking us to take the evidence in the light most favorable to the state,
At least for the sufficiency.
which is what's required.
Correct. To just sort of finish my point, I think, courts have for a long time determined that simple commission of an act itself is evidence of you intended to do that thing. If I go, it is entirely possible that because he was driving recklessly or negligently, caused an accident. What is also entirely possible is that for whatever reason, he knowingly crashed his car into the back of this victim's thing. And I think the mere commission of that crash for the first time is evidence in and of itself, circumstantial evidence of the mens rea.
I was intended to, my question was really in furtherance of Judge Kinsley's question with regard to the means of a deadly weapon and whether there is a mens rea that's embedded in that.
So I don't
and
think...
you had responded by talking about the nature and the manner of use. So really my question was in furtherance of that with regard to, in this case, that AC is driving a vehicle.
So in my argument, I guess, is to more lay it out in terms of what I've just said, is that if I've decided to crash my car into another person, if I've done that knowingly, because of the nature of a car, which is obviously capable of inflicting great bodily harm or death, the use of that to crash into another person would turn that car into a deadly weapon. To take me back to my hammer example, obviously, if I have a hammer, it's a blood instrument. It can cause great bodily harm or death if it's used as a weapon. So by using it as a weapon knowingly, that turns that hammer into a deadly
Is mere knowledge enough? I mean, we're talking about the dividing line between an ordinary traffic accident and a second-degree felony. This is a serious question.
Sure.
How do we distinguish between someone who might know in a split second, oh gosh, I'm going to hit this car, and what I think is the dividing line that the law is trying to strike, which is some kind of purpose or intent or desire or meaning to accomplish the ultimate objective of a crash? What's that look like?
I think what that looks like, it looks like it in this case, which is, you get a fact finder, you put them in front of them, and you have them examine the totality of the circumstances of what took place, not just before or right at the moment of the crash, but you look at what took place after. I mean, I haven't been in a lot of car accidents, but the car accident that I was in, got out of the car, examined the damage, got the information for the other person, either, I won't say I admitted fault, but talk to the other person about the circumstances. And obviously there's the circumstances of the crash itself. Was one person stopped too long? Did someone's brakes not work? But here, I mean, I don't think it's, when we examine the circumstances that the court did in this case, I think, you're talking about that line, I think it pushed far over the line and turned into a felonious assault when we look at the totality of the circumstances.
So it's a case-by-case inquiry.
Certainly. I think here what took place was the AC, hanging outside of the window, in my opinion, full control of the car, and also in the court's opinion, in control of that vehicle.
Counsel, how in the world is he in full control of the car hanging halfway out the door?
Well, you can see him in State's Exhibit 5. He's operating the vehicle, and he doesn't appear to be operating the vehicle with any difficulty.
But it just strikes me that if the intent was to kill this woman, that detracts from that he was, in I think her words, just kind of goofing around in driving the car and hit her as a result of that. But in terms of the specific intent to try to use the vehicle as a deadly weapon, it seems like that would detract from that versus him focused on aiming the car at her.
I think both of those are interpretations of the evidence to be made by the fact finder. But to be clear, and I want to be very clear about this, the state does not have to prove that he intended to kill her with the car, or that he, again, I also...
Use it as a deadly weapon.
I do not think we have to demonstrate a specific intent to use the car as a deadly weapon. I do not think we have to show that in his mind he was like, I'm going to use this as a deadly weapon. I think we have to show that he knowingly intended to cause her physical harm or attempt to cause her physical harm knowingly, and that he did that with a deadly weapon. And that car, whether it's a deadly weapon or not, is to be determined from the circumstances. I think a car is much different than a bike in that sense. If I had attempted to hit you with a bike, I think certainly you would agree, a car is far more capable of being a deadly weapon than a bike or a skateboard is.
Right.
And so when
But the capability is not the issue. If my intent in hitting you with the bike was to cause you deadly harm, then it becomes a weapon, right?
If your intent is to, if I intend to hit you, to cause you physical harm with a squirt gun, I can still intend to cause or still attempt to cause you physical harm with that squirt gun. But I don't think I can say that I've done it with a deadly weapon. The same is not true for an actual gun. Or, talk about a toy sword versus a regular sword. In both cases, I can knowingly intend, specifically within my mind, to cause you serious physical harm with a toy sword. But whether or not that toy sword is a deadly weapon is going to be determined from the circumstance. You have the nature of use on both swords, but the actual nature of the swords itself is that other element. So I think the distinction that I'm making is the car is more akin to a real sword, whereas a bike or a skateboard might be more akin to a toy sword. In each instance, you have someone who is knowingly attempting to cause physical harm. It's just that in one scenario, you're doing it with a deadly weapon. I disagree with you, Judge, that there would have to be some sort of specific intent there that the state would have to prove. I think that the only thing that the state has to prove is that it was a deadly weapon. In this case, because it was a vehicle used in this sense, I think it was. I don't believe I have any further time. Thank you.
Thank you very much.
Thank you, Your Honors. So first, I just want to circle to the manifest weight. So if this court finds that there is evidence from which someone could possibly infer intent in this case, then it is our position that the facts and circumstances that surround this incident are such that the trier of fact clearly lost its way in finding that AC committed a felonious assault in this case. And we would ask that this be reversed and either remanded for a new trial or that it be reversed and discharged. Obviously, it is our primary position that it should just be discharged. This wasn't a felonious assault. One of the things that I also want to address is regarding the facilitation specification. I just want to clarify that a facilitation specification is not an independent charge. It is a sentencing enhancement. So both portions of the statute that talk about what is required to establish a facilitation specification. So while committing the offense, possession of a firearm while committing an offense, and using, displaying, brandishing the firearm to facilitate the offense. Both of those.
I don't think that applies here. It's simply display, brandish the firearm, indicate that he possessed the firearm, or use it to facilitate the offense.
So there is case law, and I believe it is cited in the brief. And so what I'm trying to clarify is that all portions of the statute have to relate back to the predicate offense. It is not a standalone offense, and so whatever offense it is predicated on, both portions of that statute have to apply to that predicate offense. So the while committing the felonious assault and to facilitate the felonious assault would be required in order to establish the facilitation specification.
When, from your perspective, and I understand you're challenging the sufficiency and weight of the evidence with regard to the felonious assault, but for the purposes of my question, let's just assume that a felonious assault occurred. From your perspective, when did it end?
It would have ended based on the court's decision and based on what was alleged once that second tap of the vehicle was over. That was the felonious assault. The deadly weapon, according to the court, was the automobile. So there's no allegation that the felonious assault continued after those collisions. The collisions were the felonious assault. And so when AC allegedly pulled up to the side after that, the felonious assault was done, much like when in Peacock the vehicle hit the bike and then stopped. That was the end of the felonious assault. And that's the same here. I also
just want to make sure, because I'm a little confused here. Are you saying that both the while committing the offense and used it to facilitate the offense are required? That both of those elements?
to establish a 3-year specification?
Correct.
Yes.
Okay. So the or doesn't have, so, because there's an or in there, so you must be reading the or differently than I am.
So there's some case law that helps clarify this. There is also, if you look further down in the statute, it's worded slightly differently. I will say, I think that it's a weirdly worded statute, but farther down in the statute, there is a portion that changes where that or is and would suggest that the display, brandish, use, indicate all relate to facilitation of the offense. And I think that that is also consistent with, even if we're looking at the naming of the statute, relating to, you know, that's the distinguishing factor between possession, mere possession of a firearm, and facilitation. The other part that I want to talk just briefly about is operability. And I think that in this case, the evidence doesn't support a finding that the alleged gun that the witness believed she saw AC holding was an operable firearm. And I will acknowledge that there is case law that is not very helpful. I think the case law has really watered down what is required or what should be required. But it is clear from the case law that there needs to be some action or words used by the defendant that would support a finding that the defendant was holding out the firearm to be real and to be operable. And in this case, we don't have that. There wasn't pointing, there were no circumstances such as shell casings, there was no sound, he didn't cock the weapon, he didn't implicitly or explicitly threaten the victim with the weapon that he was alleged to be holding. And if we continue down a path where anytime there's an allegation that someone is holding something that appears to be a firearm, that is enough to establish that that person should receive an additional 3 years in prison, that is a problem. That is a problem. And so I think that, you know, there is case law that supports that there needs to be something more. There needs to be something to indicate.
So let me
that
ask
it
you
was real.
this. The testimony begins with, this is the first statement out of the witness. He pulled to the side of me, and then that's when he told me to pull on the side street, and that's when he, I don't know, that flashed the firearm at me, and he did hold it up to let me know that he had it. So showing the firearm and telling her to pull up a side street, is that enough? Is it not? I'm sure you're going to say it's not. That's cool. That's what your job is. But I want to understand from your perspective for sure.
Yeah, from my perspective, that's not enough. If he had pointed it at her, that would be enough. If he...
So saying pull up the side street while showing a firearm.
I think if we look at the totality of the circumstances, which is immediately thereafter, he left. He left. Like, he sped off. They never had any further contact. She also indicated that he seemed like he was joking. He didn't seem, like, there was no allegation that he seemed threatening about it. There was nothing that he was allegedly seeking from her. And so, yes, he held up something that she thought might have been a firearm, but he didn't hold it out in a way or use it in a context that would I think, support an inference that it was in fact a firearm or that it was an operable firearm. And then just very briefly, because I know I'm probably out of time, regarding our decision not to file a specific cause or assignment of error relating to the aggravated menacing. That is not relating to us finding or believing that that was a legitimate charge. That is related to my client's wishes and wanting to focus in on the more significant charges. And so while I understand the state's perspective, and we did challenge it based on manifest weight of the identity. So I guess to wrap things up, unless there are any other questions.
I do have one more question. Because, you know, a lot of your argument is really centered on sufficiency, and you're also arguing manifest weight, and I understand that. Because your position on some of these is that there was an issue with sufficiency, and some of those arguments on sufficiency were not raised at all in the objections, why didn't you assert an ineffective assistance of counsel with regard to trial counsel?
So it's something, to be completely honest, it was something that I had strongly considered.
Counsel, was AC represented in this trial by someone within your office, or this is the Cuyahoga County?
This is the Cuyahoga County.
All right, thank you.
And to be just straightforward, AC doesn't want to go back and have another trial. And so if it had just been ineffective assistance of counsel, and if it was going to be remanded back down for him to go through this process again, that's not really what he wants. We would take it, don't get me wrong. Like, we would absolutely take it, because this is not a charge that he should have ever been adjudicated on. But after talking with my client, the decision not to file for ineffective assistance of counsel came from a strategic standpoint. It came from a client-centered approach to this advocacy standpoint. And so we tried to focus in on the issues that were, we believe to be our strongest issues. And it is also extremely difficult when it comes to identity to, well, the other thing is, because a facilitation specification, that argument is based on the interpretation and application of the law, we believe that that's something the court can consider without us having to raise ineffective assistance of counsel. Regarding the identity, the case law on identity is very difficult. And so without that, there were a lot of steps that we didn't know if it would water down everything else. Mm-hmm. So
I appreciate all your efforts this morning.
yeah, thank you. So,
And counsel, you're
way over time. Yes. So we would just ask for this to be reversed and either discharged or remanded for a new trial. We would also ask that the court consider reversing for resentencing, and we appreciate your time. Thank you.
Thank you. Thank you both for your arguments this morning. We appreciate your advocacy. We will take the matter under submission and issue a timely decision. The next case on our docket this morning is N. Re C and S Children, C250018. I understand we have 3 attorneys arguing on the appellant's side. We may need to relocate some chairs to make room for you, but please feel free to come forward. And feel free to organize yourselves as you need to.
That is okay if I sit?
Absolutely, yes. As long as you all are okay with that. Thank you. Thank you. Thank you for your professionalism. All right. I would like to outline my understanding of how you would like to argue this morning so that we're clear on who is doing what when. First, Mother's Counsel will argue for 2 minutes with 3 minutes reserved. Is that still your intention?
That's correct, Your Honor. Thank you.
Then next, father's counsel for 5 minutes with no rebuttal time.
That's correct,
All right, and then the guardian ad litem's attorney for 5 minutes with no rebuttal time. Is that still your intention? All right. So if counsel for mother would like to come forward first.
Thank you, Your Honors. Good morning. Your Honors and counselors, may it please the court. My name is Alex Vanderzee, and I represent mother on this case, Jennifer Blackgrove. And we're here regarding her two of her children, a 7-year-old and a 9-year-old boy. And her case involving Hamilton County Job and Family Services. This is a case where
Counsel, I have a question for you about the ICPC process.
Yes.
Would mother have had an opportunity to file any proceeding in Kentucky challenging the outcome of the ICPC investigation?
She would have had the ability to object to an outcome, but that wasn't what she was trying to do.
What is that process in Kentucky?
Well, that's a good question. It's a little bit outside of the realm of what I can do because I can't request them myself, so I can't ask that they be
Is there a
redone.
statutory remedy for her to appeal the finding of an ICPC investigation?
There is, to appeal the finding of it, yes. But that's not
what is that? What statute is that?
I don't know, Your Honor. I apologize. I don't know the statute.
Well, you've advanced a due process argument that essentially, and I don't want to put words in your mouth, but reading your brief, you've advanced a due process argument that mother did not have an opportunity to either challenge the ICPC findings or to obtain another ICPC investigation. And so I'm trying to really understand what exactly the process would have been for her to challenge the outcome of this determinative evaluation.
I believe I don't know the statute, but I believe in Kentucky, she would have had to call somebody at the cabinet and said, I want to appeal the result of my failed ICPCs. But that's not necessarily what happened here.
And that would be an internal process or a
so.
judicial process?
I believe an internal process at the cabinet. I believe, but
Is there
I'm not
judicial
sure.
review?
I'm not clear, Your Honor. I don't know about the Kentucky's process.
Well, it seems to me, I mean, the trial court, not the magistrate, the trial court, made a finding that it could not place these children with their mother because Kentucky had denied the ICPC placement. And that essentially outsources what should be a judicial determination at the disposition stage to an administrative agency in another state.
Correct.
To paraphrase, it gives an absolute veto to the Kentucky cabinet over the juvenile court's judicial decision.
Yes.
What process is there for mother to remedy that?
For that more constitutional kind of argument, I believe we need to the laws need to change on that. But for today's purposes, I was more focused on the agency's outright refusal to even request to do that ICPC, that I'm going to call it the fourth, but I'll explain why it's not the fourth ICPC. I don't know if there's enough time in this expedited hearing to talk about those kind of bigger constitutional issues. I did put them in my brief, but for today's purposes, I was prepared to talk more about why the agency's outright refusal to give her an ICPC should.
What statute or law or rule or provision or case law authority compels JFS to conduct another ICPC referral?
Well, Your Honor, if it's part of the agency's case plan services, so once the agency comes up with its case plan and after disposition, it becomes a court order to do the certain things. That can be anything from parenting classes to your diagnostic assessment, to your drug screens, to an approved ICPC. All of those things and more fall under a court order in your case plan services. In this case,
So was JFS then in contempt of the journalized case plan?
Absolutely, I believe so.
And was there a motion for contempt filed?
There was no official motion for contempt filed. There were requests for them to follow the case plan, to do their case plan.
Could there have been a motion for contempt filed?
I don't know, but I believe there could have been. I also believe without that being filed, JFS and the court are required to act according to their own case plan. That's what's expected of my client, and she complied. What didn't happen is JFS didn't follow their own case plan by simply submitting a final ICPC that they knew or should have known would have been approved and would have reunited this family.
I'm looking, Lauren Jones's testimony seems to suggest that Hamilton County JFS could have made another ICPC referral.
Absolutely.
Okay.
They could have. They could have. There's no limit to the amount that they can make.
So,
And-
so it's not wholly, and I don't know, I mean, I don't know the answer to Judge Kinsley's question either, but it just appears that perhaps it's not wholly within the hands of Kentucky if Hamilton County JFS is able to make another ICPC referral.
Yeah, it starts in the hands of Hamilton County JFS. They're the ones who have to step aside and send the email to say, hey, hey, Kentucky, can you do this ICPC for us? It's in their hands and only their hands. I can't make that request. The GAL can't make that request. My client can't subcontract with anybody else to do that request. Unlike maybe other case plan services like a psychological or drug screens, or I've been doing this for 11 years and helping parents on the abuse, neglect, dependency panel. I have my own list of resources I can give them if JFS doesn't give them the things I think they need to do. There isn't one for
What
an
provision
ICPC.
in the case plan would, in your mind, require JFS to order another ICPC?
The fact that it was a requirement within the case plan service itself, just like having to take a diagnostic assessment or mom had to complete substance abuse counseling.
I suspect they're going to say, because it was addressed in their briefing, that, and the trial court's order as well, that that parents are not entitled to an unlimited number of ICPC referrals. So at the end of this spectrum, right, we could have a parent saying, I want a new ICPC referral every single day. What if anything, governs the frequency of these, or under what circumstances they're supposed to occur?
Yeah, understood. Nothing yet. I think if it was to be, the safest thing to do would be to literally outline that in the case plan service itself. So you are required, client, to get an ICPC, and you have 3 chances. I mean, that could be put in there and outlined in there. I don't see why not.
And that was, language like that was not in this case?
No, that was not included in this ICPC.
Counsel, what about this 2-year statutory maximum that the children could be in temporary agency custody? Did that prevent the fourth or the subsequent ICPC from having time to be requested and completed?
Well, I don't think that was ever necessarily outlined specifically by the magistrate. I do believe that since this case was open from 2019, that they run up against calendars, and I think that affects how they go forward on cases sometimes. I think it's unfortunate. However, I made many requests, personally made many requests, either out loud to the court or in written email form to the prosecutor at the time, not Ms. Bradbury, but Mr. Daniel Monk. Not only did I make requests, my client made requests.
Isn't this a flaw in the process that you're pointing to, that a parent is powerless under Ohio law to compel the investigation and documentation that they need to protect their parental rights?
Yeah, absolutely. You should be down here. Yes,
I thought you indicated that the mother would have an opportunity to challenge the outcome of the ICPC.
For clarification, she has an opportunity to appeal the result of one that happened. She can say, I didn't like that result, you need to redo it. But she can't ask for it to be done. And she didn't want to object to the prior ones. And for clarification, I'm calling this one the 4th denied ICPC, but it wasn't really. Only one of them was actually denied. 2 of the other ones were just never completed. The letter we got back said, she's not at a point in her case plan services where we can even do an ICPC. So really, this was only the 2nd one that could be completed.
And was that inability to complete it a result of her still having the father, or still having contact and a relationship with the father?
No, that was an allegation. Then the allegation was of domestic violence, but that allegation was unsubstantiated. Kentucky investigated it, and it was unsubstantiated. That's what's the most important thing here.
But didn't she have an ongoing relationship with the father? She was caring for the father's mother, borrowing the father's car. There was continual involvement with the father. Wasn't that established?
I don't think they were in any kind of romantic or otherwise
No, I'm not
situation.
suggesting that, but there was ongoing interaction between the two.
I'm trying to remember now. I do believe there was some car borrowing, but that was not the reason that this alleged domestic violence was brought up.
And I guess my question, was that the reason that the ICPC could not be completed, because of the ongoing relationship?
No. The only reason that the fourth ICPC was not being completed was because JFS refused to make the request. Outright refused, despite my requests, my client's request, the GAL's request, father's attorney's request, literally said, no, we're not going to make it. I'm not going to do it.
And counsel, if you'd like to reserve time, you're out of time.
Okay. Thank you.
Thank you. Next, we will hear from Father's Counsel.
Good morning, Your Honor. Cynthia Doherty, I'm attorney for Father Mr. Cox, who's the legal father of FC.
And
I think
am
I can answer
understanding the record correctly that he also petitioned for custody of the other child?
SL. That's correct. He's petitioner, but not father, alleged or otherwise.
All right, thank you.
And I have hearing in one ear, so I'm probably going to talk a little louder than you would, but I know you have a very soft-spoken voice, so I think I can answer some of the questions about the ICPC, if Your Honor will allow me. My client, Mr. Cox, does support reunification with mother in mother's home in Kentucky. It appears that 2 of the ICPCs that were ordered by JFS, those were not done because mother had not progressed long enough in her case plan services for those to be completed. Then we come up on a 3rd one. That one was denied for income at the time, and there's this allegation that Mr. Cox, my client, showed up at the home to let mother know that there was a genetic heart condition that he had that the child may also have, and that was the only purpose for his visit. I think in the record you'll see that the caseworker showed up at the home, said maybe she thought she saw Mr. Cox, but couldn't really clearly say she did. Mother
Are
doesn't.
these the kind of facts that could be addressed in some form of judicial appeal in Kentucky if mother, in fact, had the opportunity to appeal the 3rd ICPC finding in that state?
I don't think mother was trying to appeal that. I think they were trying to get through, because there wasn't anywhere you could go with it, because while there's a family services open case, it's always going to be denied. So in this case, because of that allegation of domestic violence based on the history of the couple, that Kentucky cabinet opened a case. So as long as that case is open, no ICPC is going to pass. So that's
an appeal would have been meaningless.
correct. However, later, the cabinet found it unsubstantiated, the domestic violence, that there was no concern that there was domestic violence between the 2 of them, Mr. Cox and mother, at the time. They came and testified that it would be a much faster process to do an update. But I think if we look at, I think they are required. I think JFS is required under the law to go ahead and submit another one. And I don't know that
What law compels that result?
I think if we look at the purpose, the 510323, and we look at the purpose, it says each child, I quote, each child shall receive the maximum opportunity to be placed in that other state. So it's not very clear or defined as to how many times, but here I'm sort of looking to all procedural processes for parents. This is a procedural process. We are at the finish line. It has been in, to your point, Judge Moore, that it has been in since 2019. We are across that 2-year. But it seems to me that the agency acquiescence that additional time We're still working services. This is the last issue. Everyone agrees that this is the last issue for this family. Mother was required and completed the domestic assessments, the individual therapy, the random drug screens, which later were not even considered as an issue anymore. She participated in visits. She went to all the medical. She has income. She had housing. That was all investigated. Kentucky came forward and said at trial, and you'll see that in the transcripts, we will do another one. It's worth it. We don't have a limit. There is no limit according to them. All we needed was for JFS to let them know to go ahead and do that. And they would have gotten that done very fast. And they testified to that. I think to look at this too, I think in the judge's opinion, it talks about, the court, I make a distinction between when the court may grant permanent custody and when they must. That may and shall distinction. And here, I don't think B2 applies. I think that these children can be placed with mother within a reasonable amount of time. That's the only thing we're waiting on. I think that under B1, the 2151-414B1, that statute says the court may. They don't necessarily have to under the facts in this case. They may grant permanent custody. We still have one more thing out there that potentially could really change the outcome of this family. This court, dependency court, is a court of best interest. And I think it would be in the children's best interest, given all of the services that mother has done, to place these children with mother, or at least reverse and remand back to the trial court to get this additional updated ICPC. I think that could be done in a reasonable amount of time, and that would be our answer. I believe that that is the only issue left in this case. It's unusual that we get to this point on these PC trials. It's unusual for us to have, I think, a strong arguments against this D2 mandatory shall.
Well, the trial court did not apply the mandatory provision, right?
I think they applied D2. They attempted to apply D2 under E1, 4, 10, 14, and 16.
Well, didn't the trial court overturn the magistrate's analysis in that regard following our decision?
That's possible. That yes, because you had a recent decision that
Yes.
if they didn't exist at the time, that it wasn't to be allowed. But I think under B1, that may in the statute is critical, because the court doesn't have to go ahead with the PC. They can consider all the evidence which weighs in favor of mother and reunification, and they can actually say, okay, I think under the law, because children are allowed every opportunity, the maximum opportunity is what that purpose says.
Counsel, you're out of time if you'd like to wrap up.
Thank you, Your Honor. Apologize.
Thank you. And next, we will hear from counsel for the guardian ad litem.
Thank you, Your Honor. May it please court and counsel. I'm Jeff McCormick. I'm the attorney for the guardian ad litem and the court-appointed special advocate. I will try and answer some of those questions that you had a little bit later, but as you know, the guardian ad litem's responsibility is to talk about the best interest and provide a report to the court. The transcript and my brief in particular lay out how the guardian ad litem felt about the best interest of these children. I'd also like to point out the guardian ad litem has had this case longer than any of the professionals in this room, other than, well, actually she's been longer than any of the caseworkers.
For the duration,
For the duration of this case. She's been assigned to it. And Ms. Rickert, the court-appointed special advocate, has the second most experience with these kids and the families. as Ms. Doherty was saying,
And counsel, it's my understanding that both of these children have expressed a desire to remain with their mother.
that is correct.
And was that expressed to the guardian ad litem and then conveyed to the court? Or was
Yes.
that done in camera?
I don't recall there being an in-camera, but the magistrate did indicate in her decision, and the judge adopted that decision, that was the desire of the children, was to be placed with mom. Regarding Ms. Doherty's issue or statements about RC 2151.414D2 being used, you're correct. The judge did overrule that part of the magistrate's decision, but something that I found curious about that was that, let me find it here. First of all, D2 section of 2151.414 has 4 factors. All 4 of those must be present in order to even consider that section of the statute. And as was said earlier, that statute says if you find these 4 factors, then you have to commit to permanent custody, and you have to find that the court has to find that it's in the best interest of the children to grant permanent custody. Again, all 4 factors have to be present. The judge found that one of those factors in there was that the children had been in custody for 2 years before the PC filing was made. And there was a recent decision in this court, in re PSM Children, 2024 Ohio 2794, which pointed out an error in that case, which was similar to the one in ours. So the judge found correctly that 2151.414D2 did not apply. However, she later says, despite the court finding that a mandatory commitment of the children to permanent custody of HCJFS is not appropriate, the court is in full agreement with the magistrate's decision and analysis regarding the remaining factors under 2151.414D2 and 2151.414D1. I would argue that if that factor from in re PSM is not present, then you shouldn't be considering any of those factors. So, and here, and again, the judge doesn't lay out which specific factors that she still found agreeable. She said all of those factors were agreeable. But again, I don't think that has that portion of the statute has any relevance to a PC decision in this particular case.
Do you have any perspective as to whether the case plan compelled a 4th ICPC?
I don't recall if there was any specific language in there that would compel an ICPC, but as was stated by other counsel here, there had been at least 2 that were submitted that were basically turned back to us for procedural reasons, or back to the agency for procedural reasons.
Those are the 2 earlier ones?
Yes. Specifically, I know one of them said we can't do an ICPC right now because mom still has supervised visitation.
Now, my understanding of the 3rd one, at least mother's perspective, and perhaps yours as well on the 3rd one, is that the 2 barriers identified in the 3rd ICPC, which were a lack of income and the pending DV investigation,
Correct.
were remedied.
Correct.
Is that your belief as well?
It is, Your Honor, and I believe the testimony from the workers from the Kentucky cabinet at the PC trial bear that out. Again, going to the factors in 2151.414D1, just to highlight some things, and again, these are in my brief. Let me go to Section A, the interaction with the children with other people that are significant in their lives. The GAL testified that these children have a great relationship with their mother. Mom is involved in the care for these children and her involvement with their medical and therapy services. She contrasted that with the foster homes. There were some issues which I don't want to get into here on the record, but they're in my brief and in the testimony itself. JL said that the boys are in a good space when they're around mom, saying that the boys thrive around mom. And how do we know that? At the time this last ICPC was denied, the children were already living with mom. Whoops, I'll take that back. I'll rephrase.
Unsupervised
They weren't living with
visitation.
mom, but they were having overnight visitations with her. Agency in Kentucky had no problems or any concerns with mom. In fact, mom had 2 other children of hers that were living in the home already. And at no point, even after this investigation that they did, or during the investigation, did they have any concern that would warrant them taking those children out of the home.
Counsel, if you can wrap up.
Sure. Again, I believe that the weight of the evidence regarding the best interest factors clearly weighs with the children, and for the most part, the decision itself from the court bears that out as well. Thank you.
Thank you. Counsel for JFS.
May it please the court and counsel, Patsy Bradbury on behalf of HCJFS. Your Honor, what this case basically boils down to is whether or not a 4th ICPC would get mother what she wants, which would be an approval by Kentucky to place the children there. The evidence below does not support that. As a matter of fact, Lisa Schaefer, one of the directors of ICPC for the Cabinet of Kentucky, said that if mother still had supervised visits, they would not even accept.
Well, counsel, aren't we all speculating as to what the outcome of a 4th ICPC might have been?
No, Your Honor, I don't believe that we are. Kentucky would not even accept the referral for the 4th ICPC as long as mother still had supervised visitation.
Where in the record is that information?
Your Honor, that would be Lisa Schaefer's testimony, the July 31st, 2024, page numbers 23 to 24. If all of the case plan had not been completed, or if the parent still has supervised visitation, would send a letter to the requesting state saying at the time they are unable to accept the request.
Well, isn't the reason, and correct me if I'm wrong, but my understanding on this record is that the reason why the children transitioned from unsupervised visits to supervised visits was this unsubstantiated domestic violence investigation.
Your Honor, that is correct.
And so why did JFS not resume the unsupervised visitation that occurred prior to the unsubstantiated domestic violence?
The agency did not resume unsupervised visitation due to the ongoing concerns with the nature of the relationship between Mr. Cox and mother. Mother did not disclose the domestic violence situation to the agency at all. We only found...
But she disclosed it to the police.
The police were called. She was not the person who called the police.
Wasn't she interviewed by them?
I would assume so, Your Honor, but there were no charges made, but she also didn't disclose the concerns of this domestic violence incident happening to the agency when during the entire course of this case, spanning nearly 5 years at the time of trial, there had been ongoing concerns for domestic violence. The testimony regarding mother was that she was still in contact with father. She transported he and his mother using his vehicle to the appointments. So that was the concern, was that...
Well, that testimony came at the ultimate trial, right?
is-
So JFS couldn't have based its decision to engage in supervised visitations almost a year and a half prior based on testimony that she offered at a hearing in 2024.
Correct, Your Honor, but there was the issue of the truthfulness of mother and her ability to relay to the agency concerns regarding the domestic violence. Initially in the case, she had stipulated to father being physically violent with her, and there was, throughout the course of the case, that remained a concern. And then once this incident regarding the denial of the 3rd ICPC came to light, that solidified, the agency's concerns about the relationship between mother and Mr. Cox. And that is why the agency did not go back to supervised visits. But the other issue is, Your Honor, even if Kentucky had accepted the 4th referral for ICPC, which would have come 5 years into the pendency of this case, there is no guarantee that the Kentucky would have approved. There were concerns about the lack of income during the 3rd ICPC denial. the testimony that came out at trial was mother was unable to assume full-time employment at the time due to her other obligations in transporting Mr. Cox, his mother, and one of her other children. to
Counsel,
his-
there's been a due process argument asserted by mother in this case. And on the record, it appears that the trial court, in essence, outsourced its obligation to make a dispositional finding by giving a veto to Kentucky. There was a finding by the trial court in its decision overruling the objections that it could not place these children with their mother because Kentucky had denied the ICPC. What remedy does a parent have in those circumstances to challenge the finding of an administrative agency in another state?
Mother could have done an administrative appeal in the state of Kentucky.
Well, let's talk about that, because KRS 199.473, which I believe to be the provision in Kentucky that provides parents a right to challenge ICPC investigations, only applies to adoption placements. It does not provide an administrative appeal for parents. Can you address that?
Not that specific provision, Your Honor, but I do believe that 922 Kentucky Administrative Regulation 1:320, Section 9 provides, an individual aggrieved by an action of the cabinet may request an administrative hearing for the matter by which a Kentucky revised statute or 922 KAR Chapters 1 and 5 expressly permits the appeal of a cabinet action or alleged act. So I do believe that mother would have had an administrative.
Internally. So
Yes.
she could have called someone at the cabinet to have said, I dispute this ICPC, you're not making this decision based on information that's accurate to my family.
That is
But
correct.
what about judicial review?
Section KAR 23.1.101, Section 4 states that the circuit court may be authorized by law to review the actions or decisions of administrative agencies. So it does appear that mother would have been able to challenge a denial of an administrative appeal within the state of Kentucky if she had chosen to do so. So I do believe,
And can you address the argument that the case plan compelled a fourth ICPC?
Your Honor, the case plan indicated a referral for an ICPC. It did not indicate a number of ICPCs that must be completed before mother could pass one. I think the important thing to note in this case is the time frame that we're looking at. The first ICPC referral was made after 2 years into this case. The second ICPC was made more than 3 years into the case. And this third ICPC was made in, 2023, which was 4 years into the case. This court has on multiple occasions indicated that a parent is provided a reasonable amount of time, but not an indefinite amount of time to remedy the conditions which led to the removal of these children. What is important is these children need permanency, and the statute, when they enacted the 2-year requirement for the amount of time that children could remain in temporary custody, sought to avoid the legal limbo that these children are currently in. Counsel has argued that if JFS had only made the fourth referral, then it would be approved. The record doesn't bear that out. It doesn't even bear that the Kentucky cabinet would have accepted the fourth ICPC. If they had, then there would have been an investigation that Kentucky would
Do
have.
they have discretion to accept the referral, to conduct the investigation, or are they required under the ICPC compact to conduct the investigation?
I believe once they accept the referral, then they would be compelled to do it, but they're not compelled to accept the referral, which is the point that I was trying to make in this instance, based on the fact that mother still had supervised.
Let me make sure I understand.
Yes, Your Honor.
So let's say hypothetically, a parent who lives in Hamilton County moves to Indiana, and there's an allegation of abuse, neglect, and dependency. There's an investigation into the family, and the case plan calls for an ICPC referral to Indiana. Am I understanding correctly that Indiana could say, we're not accepting the referral and we're not investigating this parent?
Yes, Your Honor, they could. In this instance, Kentucky on 2 separate occasions denied to accept the referral from HCJFS based on mother's status and case plan services.
And is that appealable in these other states?
I believe there are also administrative issues, proceedings that they can address in those states as well, because there was no judicial remedy in Ohio to compel that state to review it. The parent would have to request the administrative appeal within that state. But this court has on multiple occasions held that without an approved ICPC, a child shall not be placed in the receiving state. So unfortunately, at this point in time, because there is not an approved ICPC, the agency or the court could not place this child in Kentucky or these children in Kentucky. And for the best interest.
Are there any standards that govern JFS's decision to seek an ICPC referral under the case plan?
Your Honor, I believe that we had done it throughout this case, but when we hit the 4-year mark, which was way beyond the statutory time frame, at that point in time, with the multiple denials and denials to accept the referral, the agency declined not to do a fourth ICPC. I don't believe that counsel cited anything that would compel us under law or case law to continue to conduct multiple ICPCs until they got the result that they were seeking.
So it's a discretionary determination by JFS whether to engage the referral process?
Yes, Your Honor. Yes.
This 2-year statutory maximum, it's not really a maximum, right? Because you've said this has gone on for 4 years.
The amount of time that a child is to remain in temporary custody is bound by statute to 4 years, or 2 years, unless there is a motion pending. And unfortunately, in this case, due to different procedural issues determining paternity of the children, it went beyond that period of time. So it was pending only because of the pending PC motion.
Well, was the 2-year statutory maximum, did that come into play at all with respect to the fourth ICPC?
You know, I believe that when we hit when the 4-year mark approaching 5-year mark, that was when the agency decided at this point in time, given the knowledge that Kentucky would not accept the fourth referral based on mom's current status in the case, I believe that did play into the factor because at the point in time we were trying to seek permanency for the children by resolution through the court. Even if the Kentucky cabinet were to accept a referral for the ICPC, they would have to conduct an investigation, and then the children would have to remain there an additional approximately 6 months before Kentucky would give concurrence for legal custody, so that would be an impermissible extension of temporary custody.
And I guess that's my question. You could not go past the 2 years to conduct the ICPC?
No, Your Honor, we could not.
When did the 2 years expire?
The 2 years would have expired on September 3rd of 2021, Your Honor.
So then why was an ICPC requested in 2023?
The ICPC was requested in 2023 because there had been 2 prior denials at the point. We were still pending the case coming up to a permanent custody trial, and the agency is always tasked with continuing to provide reasonable efforts to reunify a family if possible, even up to a permanent custody trial. So we were attempting at that point in time to engage in the reasonable efforts. Once the trial had started, and it was unlikely that Kentucky would accept the referral, and we were looking at an additional unpermissible extension of temporary custody, that is why the agency decided not to do the fourth ICPC referral.
So there are permissible extensions that are available?
After the 1 year of temporary custody, there are 2 permissible extensions of temporary custody up to 6 months each. So after we hit the 2-year time limit as far as extensions of temporary custody, the agency could not continue to, this would be an unpermissible extension of temporary custody.
Okay, so this 2 years is an absolute limit in this case.
It's in the statute, Your Honor, so pending, the only reason we went beyond the 2 years was just pending litigation, the permanent PC.
Well, so then were the children lawfully in JFS's custody if the temporary custody order had expired?
They were, Your Honor, because the temporary custody was being held open by virtue of the pending permanent custody motion, which was filed prior to the expiration of the 2-year mark.
All right.
I just have one question. These statutes that govern permanent placement have been rewritten where prior the underlying policy, the primary focus was reunification. Under the current status of the statutes, the primary focus is certainty. How does that play into the due process argument?
I believe it plays into the due process argument, Your Honor, by establishing timelines so that it applies to all parties, being parents and children and the agency equally, so that we aren't leaving children hanging indefinitely in legal limbo. That by laying out specific timelines for the case, that is the expectation for a parent's engagement in case plan services to make progress toward being able to reunify with their children if it's safe and appropriate to do so.
Thank you.
Were there any other questions I could answer for the court? Thank you, Your Honors.
Thank you very much. Counsel for Mother, you have a brief rebuttal available.
I think I just have 3 main points after Ms. Bradbury's argument. First of all, Lauren Jones, who was an employee of the Kentucky Cabinet, she handles all the incoming ICPCs for the Northern Bluegrass region. She came to the PC hearing. I subpoenaed her. She testified. She testified that with the unsubstantiated finding and confirmed income, because my client did temporarily lose her job at Wendy's, but then shortly after regained employment at a tree trimming service. So she was employed at the time that we asked for this final ICPC to be made. She had the unsubstantiated DV finding and income. She had both of those requirements. And Ms. Jones from the Northern Bluegrass region, who does the ICPCs, testified that they could have moved forward with this ICPC. So I'm extremely confused why JFS is arguing that they couldn't make a referral or that they couldn't do another one, because they could.
Do you agree that it was an act within their discretion?
An act within JFS's discretion?
Yes. That there was no contractual language or standard that governed when they were to make the ICPC referral, and that it was a discretionary choice.
I do not believe it's discretionary. Just because it doesn't have a specific number of times that it can be requested, I think a reasonable amount is really what we're all bound by in these case plan requirements. Here, this was a reasonable request. 4 ICPCs total, 2 had been denied because mom hadn't gotten far enough in the case. 1 was denied for employment. At the 4th and final request, it was reasonable to request this because mom would have been approved. That's where JFS stuck their fingers in their ears and decided to not listen to that. And
What about this 2-year statutory maximum? I'm still hung up on that. If it can only be 2 years, there wasn't, it appears to me, time to complete the 4th ICPS. What's your response to that?
If there's a motion pending, which there was in this case, the agency is obligated, under my understanding, to continue to work reunification services with parents until it's over. And it wasn't over yet. This was pending for a long time, and yes, it was beyond the statutory 2-year mark, but there was a motion pending which stayed that timeline. And while that timeline is happening, JFS is still obligated to work reunification services with parents. They're still obligated to give them drug screens and send them to visitation centers at the Family Nurturing Center. All of that stuff still goes on after 2 years while these cases are pending, including referrals to ICPCs. And for clarification, my client did not want to appeal any of the findings. She never did. She wanted a new one made, a new referral made. She didn't want to appeal the findings of the denial. She had remedied the issues that made that one denied, and she wanted a brand new one referred. And there was nothing that stood in the way of JFS making this referral. In fact, I believe JFS went out of their way to interfere with making this referral. And you'll see in the transcripts, as attorneys, we can't talk to the caseworkers, right? We have to talk to the prosecutors. It was emailed, it was handed to them directly, it was told, it was mentioned in court that this allegation was unsubstantiated. And the caseworker testified at the PC trial that she didn't even know that. That's wild to me, that a caseworker who is in charge of the case plan services to reunify families, in my estimation, pretended that she did not know the answer, that this was an unsubstantiated allegation. I find that very alarming.
Counsel, you're out of time.
Thank you, Your
I just
Honors.
have one question.
Yes.
It sounds to me that part of your argument is that the failure to request an additional ICPC violated JFS's duty to make reasonable efforts. Am I
Absolutely.
understanding that?
Absolutely, yes. Thank you, Your Honors.
Thank you. Thank you all for your arguments this morning. We appreciate your advocacy. We will take the matter under advisement and issue a timely decision. The final case on our docket this morning is Niehaus versus TDGGC, C240412. Good morning. You may come forward when you're ready. Would you like to reserve time for rebuttal?
Yes, Your Honor. I'll reserve 3 minutes for rebuttal, please.
All right.
Go ahead. May it please the court, my name is Charles Rust. I'm here on behalf of the appellant, John M. Niehaus, Inc. Your Honors, we contend the trial court made 2 mistakes here. First, when it found that there was no breach of contract, there were no damages due to Mr. Niehaus. And then second, that that Niehaus was not entitled to amend its complaint in the underlying case. However, we think that second point is really better addressed upon remand should we be successful in this appeal, because I don't think it was addressed on the merits. I think it was addressed as being moot, even though that's not specifically discussed in the trial court's decision. On the breach of contract issue, this is a case with a complicated and complex factual history.
But the contract at issue is a settlement agreement, is that right?
That's correct, Your Honor. And I believe the parties and everybody agrees on the factual history. There's agreement that there is a contract. The disputes here are whether there was a breach of contract, and I think in a sense the duration of the contract, and then whether Niehaus is entitled to damages under the contract.
What specific provision of the settlement agreement is Niehaus seeking to enforce?
So Niehaus is seeking to enforce the provision of the settlement agreement that says there's a limit on the number of units that can be built on this property. And if
Well,
you go,
does it say that?
it says there shall not be more than 212 units constructed on the property without without Niehaus's express written consent. And so in terms of evidence in the trial court, Mr. Niehaus, who was present at the execution of that agreement, testified as to his understanding of what that meant. There was no countervailing testimony from TDGGC from somebody who had a similar level of knowledge.
Is your position that that provision, the unit restriction, runs with the land?
It is not, Your Honor, and I think that was a misconception by the trial court. So I think the trial court thought that as well. We understand the argument that something doesn't run with the land unless it's recorded, but that really talks about notice to third parties. What we're talking about is what happens to contractual obligations between the 2 primary obligors before any transfers occur. So even if it doesn't run...
I think, undisputed by you, that TDGGC did not build the extra units.
That's correct, Your Honor.
All right, so it is, I think, your perspective that TDGGC, I'm just going to call them TD, that's much easier, that TD had an obligation to notify the subsequent purchaser of the restriction?
Your Honor, that was one of the things they could have done.
And they did, didn't they? Didn't they file this letter to put future purchasers on notice that this limitation existed?
So the parties filed a letter with the Regional Planning and Zoning Commission that should show up in the file to anybody who's seeking to develop the property. What they didn't do was specifically tell anybody that there was a unit restriction on this property as evidenced in the settlement agreement between these parties.
But let's just say for a moment, that they had told TD.
Mm-hmm.
What would that have done? Because TD was not a party. I think this is not disputed, that TD was not a party to this, I'm sorry, Helkin, the third party purchaser, was not a party to the settlement agreement.
Mm-hmm.
So it either, under your logic, has to run with the land to bind Helkin, or they have to stand in the stead somehow by assignment or something to assume TD's contractual obligation. Which is it, in your perspective?
Well, so in my perspective, what could have happened was there could have been an assignment of the contract, and there wasn't. It could have been recorded, but it wasn't.
So notice would be the precursor to a possible assignment?
Well, I believe so. I believe something had to have happened. The question, I think, is not what should have happened, but what happens when a party doesn't assign a contract? There's still a contract. Everybody agrees that there was a contract. What do those obligations mean when that party unilaterally sells the underlying real estate? And I think because of the
Doesn't contract law, and I don't mean to be flip, but doesn't
Sure.
contract law suggest that that contract means nothing? I mean, a contract binds the parties to it, and unless something occurs, assignment or something else occurs to cause that contract to bind the conduct of other parties, it's limited to the people who sign the contract.
Yeah, and I understand that, Your Honor. In a sense, that's what I'm saying, is I think this contract continues to bind the parties that signed it until it's terminated, either by law or by its terms.
What about this provision in the settlement agreement dealing with binding effect, where it says that the contract's going to be binding upon the successors, trustees, legal representatives, and assigns? Doesn't that anticipate that the contract's going to be passed along and the obligations passed along to any subsequent purchaser?
I think that's what was anticipated by the parties, and I think that's what Mr. Niehaus testified to. I think what his testimony shows is he expected somebody to tell him something or to tell the third party something about this restriction when transfers of the property were made.
Well, what is the force of that provision?
The force of which provision, Your Honor?
The binding assignment clause, let's just call it for simplicity. The binding assignment clause, what is the force of that?
Well, I believe it evidences an intent by the parties that should there be a transfer at a later time, that the action would be taken to bind whoever that third-party transferee might be.
In this case, that's Helkin, right?
Yes, Your Honor. Instead, what happened here is
What I'm
there's a
trying to
contract.
understand is this, is the core of your argument that assignor's language or assigns language then binds anyone that comes after and becomes an assignee? Or is it that the assigned language gives TD a duty and despite the fact that they failed to do the duty, they had that duty?
I think the argument, Your Honor, is that it compels them to do something. You know, the contract didn't clearly define what they were supposed to do.
Okay. So you're not arguing that the language in and of itself is enforceable as to a third party?
No, Your Honor, certainly not. What we're arguing, it's the same way that when the contract says that the building of more than 212 units is conditioned on Mr. Niehaus's consent, the contract leaves it to his discretion as to what the consent would be premised upon. And he testified in this case as to what his consent would have been premised on. And that's really the contextual argument. That's why we talk about the prior history, because the context is important there. But really
Can I ask you a question about damages?
Sure.
So Niehaus has a judgment, I understand, taken essentially by default at the summary judgment stage against Helkin for the $238,000 under the contract plus pre and post judgment interest. Why does that judgment not satisfy or bring Niehaus into a position of being whole with respect to the performance of this contract?
Well, so we think this is a contract based on the occurrence here where we can hold them liable jointly and severally. So to answer the court's question, I think nothing's been collected on that judgment, if that was the question.
Well, but you have the legal entitlement to it.
Correct, Your Honor.
You're the legal, or Niehaus is the legal owner of that money.
Correct, Your Honor. But so we believe based on the occurrence here, And I know that's another issue.
And is it your perspective that a party can collect for a breach of for the same breach of contract and the same contract damages more than once?
No, it's not. It's not. I think it is possible for us to have judgments, for Niehaus to have judgments against both parties, and then those judgments, the judgment is only satisfied when the full amount's been collected. It doesn't matter who he collects from first.
Where does this say in the settlement agreement that this $17,000 per additional unit would apply for future units?
It doesn't. And it's
So where does that come from?
So that's why the context is important. So Mr. Niehaus testified in this case that they left that out on purpose, and that they left his written consent. It would be based on his discretion, and his testimony was that everybody knew that for every unit above 212, there was going to be a $17,000 figure attached to that. And I think this is where some of the confusion from the trial court came in, because the only reason we reached back to the history, the prior transfers with Erpenbeck, was because that was the genesis of this $17,000. And so that made its way through all the transactions, through the bankruptcy proceeding, to when TDGGC acquired this property. And I think it's evident from the testimony and from the text of the agreement that there was this idea that these units have value. The unit density has value, because part of the settlement is, hey, we'll let you increase from 200 to 212 without any additional compensation, but anything above that requires Mr. Niehaus's express permission. Mr. Niehaus testified, yeah, and that would have been conditioned upon me receiving payment. We just didn't want to put that in the agreement. And I think that satisfies Ohio law. Is there a reasonable basis for the damages claimed? It's not as if we're saying, hey, we need to upgrade this to $2025. This is a $17,000 in 2000, whenever that initial agreement was. So I think there's a reasonable basis, just based on the case history, to support where that comes from. We didn't pull it out of thin air.
But it wasn't included in the contract that we're talking about.
Correct. And just as Mr. Niehaus testified in this case that that was the basis for that provision, TDGGC had a similar ability to put on witness evidence and say, hey, that wasn't our understanding of the contract at that time. Here's what we actually thought. And
Well, you got the plain language of the contract. That's at issue, and it doesn't include that language, so why would they need to introduce evidence?
So the plain language of the contract just says it's premised upon Mr. Niehaus's written permission. And it doesn't say when he's required to give that permission.
No, I'm talking about the $17,000 per unit.
Correct.
So are you arguing that there was a second separate oral contract or something, a separate second contract, which is the $17,000 for the additional units?
I don't think we're going that far. I think what we're saying is when this contract was executed, with the way that provision is written, where it's conditioned upon his written consent, there's an implication there that so he has to get something to give his consent. There's not a provision that says, well, these are the circumstances in which he's required.
So that's ambiguous. That term is ambiguous, and then we can consider the additional evidence?
Correct, and that's why Mr. Niehaus testified, well, when we wrote this, here was the understanding. And all I'm saying is they had an equal ability to have a witness or other evidence saying here was our understanding at the time, and they didn't do that. So
That's what I'm trying to understand, because the express consent that was required, the written express consent, that ties back to TDGGC agrees that it, and that it seems to refer to TDGGC, shall neither build nor apply for approval to build more than 212 units. Total in phase 2. So that's the other thing, it's phase 2. So I don't know if we're at phase 3, 4, 5, or 6, but this is all about phase 2. So there's two things here, it's phase 2, and then it going back to TDGGC. So how do you get over that language?
I think I understand what you're asking. And so phase 2, in this type of development, it just refers to this area of the development, so this Chestnut Park area that TDGGC acquired.
Thank you.
And to your other question, I think what you're asking is if Helkin was the one that built the units, how is TDGGC?
Yeah,
is that what you're asking?
Yeah, and that's why I started with the question of assignors. And you said, no, that's not your argument. So since that's not your argument, how do we get anybody else into this obligation when it says TDGGC agrees that it shall neither build?
Well, I think the way to answer that, Your Honor, is so TDGGC sold the underlying property to Helkin for money. And functionally, even if TDGGC retained the property, so let's say they retain the property and they just hire Helkin to develop it for them, that's a violation. And so I don't see how this is any different. The contract doesn't go anywhere just because TDGGC assigned the underlying, or sold the underlying real estate. The contract's still there. And to the extent that they either forgot about it or sold the property to somebody without saying something, they did
by selling the property, then they no longer have any duties, responsibilities, control, and I think control is the key word here, over Phase 2. They've given up wholly their control over Phase 2.
Understood.
Unless you have something other.
No, I understand that, Your Honor, and I think our position is they did so at their own risk. They have an obligation with Niehaus. They knew they had it, and they sold the underlying real estate to a third party, knowing that third party intended to develop it. What they should have done was say, hey, by the way, we have a unit restriction here. We need to be careful about this. And nobody did that.
See, but the other part that I also find interesting, and I'm trying to figure out what does it all mean, is that there was a confidentiality clause.
Mm-hmm.
So that confidentiality clause gives a binding effect to both parties.
Mm-hmm.
So now you're saying that there was a duty to pass on information, but yet there was a confidentiality clause that was signed. And, unless that has some sort of carve out either by the contract or by case law or by statute, I'm trying to understand how we get over the confidentiality clause.
No, understood, Your Honor. And I don't have that in front of me right now, but I believe there would be a carve out for transferees, for successors and assigns, right?
Wasn't the letter supposed to address that?
Well, so the letter was a safeguard, yes, that was put in the.
A safeguard to address future notice to subsequent purchasers.
Correct.
And in fact, the parties anticipated this occurring by including that binding effect paragraph.
I believe that's correct.
Thank you.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Matt Bakota for TD. I'll take advantage of the abbreviation as well. The question is what's in the contract? And all of the obligations that Niehaus sought to impose before the trial court weren't in the contract. And that's why the trial court declined to add them. A couple of the questions that were asked was, what was TD's obligation? What were they supposed to do as to potential future purchasers? They were supposed to submit the letter to the county. That's what they did. There was also some discussion about equal ability and equal ability to present deposition testimony and such things. The equal ability that matters in this case is the ability to negotiate the contract in 2004, the ability to use their counsel, both parties were represented by counsel, and to decide at that time what was going into the agreement. That's what they did. All of the obligations that Niehaus and Mr. Niehaus want to try to add were not included. So that's what we're focusing on. And I do have some additional remarks prepared, but I know it's been a long morning. If there is anything that I can answer, I would be happy to do so if that saves you any time.
Does the binding assignment clause bind your client?
It does not. What the agreement does not say is that TD had any obligation to notify any future purchasers of anything except as it relates to filing that letter with the county. We're talking about, we're in 2005 now. May there have been a better way to do it, something like that? Possibly, but we can only go on what the parties included in the.
What was the purpose of the letter to the county? What benefit did it give Niehaus?
No, notice. So it was, it's actually in the agreement the letter is described, and then the letter is attached to the agreement. So
Why would the parties need to provide public notice if the parties did not intend for this unit restriction to bind future purchasers?
well, I think the agreement says that it was supposed to bind future purchasers. It was the intent that it would bind them. Where the distinction is there's no intention or language in the agreement that says once TD sells it, TD remains obligated for what the next person does.
All right,
That's
so
what's not in the agreement.
you agree that there was a meeting of the minds between Niehaus and TD as to the ongoing longevity of the unit restriction if there were to be a subsequent purchase?
That's what's in the agreement, whether it's enforceable, as it relates to real estate records and such things. I don't know that I can speak to that, but we're not disputing what the agreement says. Our arguments are all based on what the language in the contract doesn't do, and it doesn't require TD to do anything besides not build in excess of 212 units when they own it, and then it obligates them to submit the letter to the county. That's it. And then as it relates to the $17,000 obligation, I think counsel said that continued to run all the way through this lawsuit. That is not the case. It was extinguished in bankruptcy back in, I think, 2004, might have even been 2003. And the
And
way.
TD was not a party to the original 17,000?
Correct. So Town Development Group purchased the rights out of bankruptcy. And when Town Development Group did that, the liabilities went away. That's, I'm a litigator, but that's about as much as I know about bankruptcy, is the liabilities went away. And that included the $17,000 that was in the agreement with Erpenbeck. Then Town Development Group transferred the property to TD GGC. And at no point were those obligations that Erpenbeck had, that Erpenbeck transferred to then Chestnut Park, which was extinguished in bankruptcy, those were done. Those never made their way to Town Development Group, much less TD GGC. That's referenced in the recitals to the agreement, not in the substantive part of the agreement that sets out the parties' rights and obligations.
Is there any damage in light of the judgment that was acquired against Helkin?
Damages in terms of money for Niehaus?
Yes.
I think the way that I would answer is Niehaus has what it's entitled to under the agreement, which is they obtained a judgment against Helkin because there's plenty of evidence that Helkin had at least constructive notice of this restriction. So we didn't get into that with counsel before, but there's plenty of evidence that Helkin knew what was going on. But Niehaus has every right now as we stand here today, every right they're entitled to under the agreement, which is to pursue Helkin, which is the party that built in excess of 212 units. And they actually got a judgment. And in fact, TD actually got summary judgment against Helkin's claims too. So Niehaus is, fully able to continue pursuing Helkin, but the trial.
So I understand it's your position that there's been no breach by TD of the settlement agreement.
Right.
Let's assume, just for the sake of argument, that there was. Is there any remedy for that alleged breach in light of the fact that Niehaus has essentially been made whole by the judgment against Helkin?
I would say no because of that, but also because there's no damages provision in the agreement. The parties back in 2004 didn't negotiate liquidated damages or any relief. It appears to be a restriction, and that's it, a restriction without any stated remedy. So, from the agreement, I think all we can tell is that if somebody was going to build in excess of 212 units, they should go get permission. It doesn't go the next step of saying, if you don't, this happens, or it doesn't identify what amount of money would be paid in excess of 212 units. all very, very easy things to do back in 2004 when the agreement was negotiated. We're in 2025, and I think the trial court was correct in not second-guessing or trying to add language into an agreement that was written 2 decades ago.
And do you agree with the argument that the language is ambiguous with regard to that unit restriction, allowing us then to consider additional evidence of what the party's intent might have been?
No, not at all. And I would question whether that was even raised before the trial court, but it was mentioned today. No, there is no ambiguity. This is a case about what's in the agreement and Niehaus's frustration 2 decades later with what's not in the agreement, but that doesn't give a court the ability to add language or change what might happen. You know, the World Harvest Church Ohio Supreme Court decision from 2016 says that where a written agreement is plain and unambiguous, it doesn't become ambiguous by reason of the fact that its operation will allegedly work a hardship on one of the parties thereto and corresponding advantage to the other. We enforce contracts based on what's written in the agreements, where it's clear, where it's unambiguous as it is here, courts enforce it. And that's what the trial court did here, and we'd ask that you affirm the trial court decision as it relates to summary judgment for TD and also the denial of the motion for leave to amend, which is subject to an abuse of discretion standard, and that decision was proper as well.
Thank you.
Your Honors, there are 2 points I would like to make on rebuttal. The first is that I don't believe it's a requirement under Ohio law that a liquidated damages provision is required to receive damages for a breach of contract.
But it is required that you prove damages, right?
But it's required that you prove damages.
What evidence of damages was presented to the trial court in this case?
And so the law states you have to have a reasonable basis for damages. And the evidence provided to the trial court was the testimony of Mr. John Niehaus, stating that the value of these units, these additional units, were $17,000 apiece. And there's contextual evidence outside of Mr. Niehaus's testimony that other people thought that was the case too. So I think
what does it mean the value was $17,000 apiece? How was Mr. Niehaus damaged in the amount of $17,000 as a result of these extra units being built?
Sure. So I appreciate you asking that, Your Honor. So the initial purchase of this property, the purchase price was premised on the development of a certain number of units due to financial constraints of the other party. And so the agreement was essentially, you can develop up to 200 units if you pay me this price, okay? But if you develop any more than that, I want to be compensated because you're getting more value out of the property than you paid for. And clearly, even in this settlement agreement, there was some contemplation by the parties.
Wasn't the original purchase price reduced in contemplation of the unit payments?
That's correct, Your Honor. Yeah, and that was the basis for the original agreement. And I understand the argument. You know, they purchased it out of bankruptcy, they free of the liabilities. I would say that, you know, in the underlying case where the settlement agreement was reached, they did argue that they step into the shoes of Erpenbeck in that case. And I think that it serves as context for this agreement. And I think there's enough context here to support Mr. Niehaus's damages calculation.
Well, that argument in terms of stepping into Erpenbeck's shoes was with respect to the payment from Niehaus for construction of the pool and pool house or other items. Is that correct?
That's correct, but you know, but they're trying to be selective about that. Well, we only want the things that are good for us and not the things that are bad. And I don't necessarily think it works that way. The other point I really want to make is their argument is essentially like, if you imagine a mortgage loan, right, and maybe it doesn't get recorded, what happens to that contract between those parties if the person sells the underlying real estate? Nobody's going to say, well, I don't owe the debt anymore because I sold the real estate. There's still a contract, and that's what we're arguing here.
I think they agree with you that there still is a contract, they just have taken, I think it's their position that they've taken no conduct that would breach the existing contract. Let me give you a hypothetical here.
Sure.
Let's say that TD were to buy the property back, and they were to develop, I think there's 236 units now, let's say they want to make it 250 units. Is it your position that the contract would still bind TD's conduct in that regard?
It is, because it's our position that it never stopped binding them in the first place. They never did anything with it.
And so what did they do that breached the agreement?
So the agreement was breached when there were units built on the property in excess of 212 as a result of TDGGC's actions. They sold the property to somebody they knew was going to develop it. And because they didn't do anything with their contractual obligations, they don't just go away. There's not a termination, there's not a provision in that contract.
So it's breached by omission?
Correct, Your Honor. Correct. I realize my time is up, so if Your Honors have any more questions, I'm happy to answer them.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day.